Good morning, wonderful fellow freedom fighters and lovers of freedom. My amazing returning subscribers and those who are watching from a distance, you guys are awesomely awesome. Peace, love, tranquility, freedom from every corner. Those watching from a distance, can you please go ahead and smack the red button and click the notification bell so whenever we upload, you'll be able to get notified. On this video, you are going to see the upside down nation called Niger area, where things must always be done in a backward system because of Fulani ways of reasoning and the ways of thinking. But one thing I know for sure, Elohim must prove himself on Nnamdi Kanu case and show to the world that he alone is Elohim. I want you to listen.
Of course, the world is aware that the matter came up yesterday. Before yesterday, it was adjourned for the hearing of our application, challenging the jurisdiction of the courts to continue or entertain the charge. 7 count amended charge filed by the federal government against our client, Nnamdi. When we file this application, which goes to the root of the charge, substantially challenging the jurisdiction of the court to hear the charge, the prosecutor, that is the federal government, filed a counter application, counter affidavit, a response to our application, and we filed our reply on law, indicating that issues have been joined by the parties. The matter was consequently adjourned to 18th, being yesterday, for hearing. So we left. That was December last year. Getting set for legal onslaught of yesterday. Because the essence of that application is that if the application succeeds, that will be the end of that case in court. And our client will be freed. The charge will be dismissed, and he will be freed and will be acquitted. Because what we are saying is that the 7 count charge, amended charge, filed against him by the federal government, not disclose any offense by the allegations contained therein. Because we cannot put something on nothing and expect it to stand. He who alleged must prove. And the law is that at this point in time, if such allegations are being leveled against somebody, there must be what they call proof of evidence that will attach to the charge. It may look at that proof of evidence will show what you expected to see in court at the point of trial, whether the allegations as contained in the paper, whether they can be sustained by that proof of evidence. So we have critically looked at this amended 7 count charge and arrive at an opinion, conclusion that they did not disclose an offense committed by our client. So we file an application to challenge it in line with the provisions of the law. Then 12 hours, 24 hours before the date slated for the hearing of this application, we are served with another amendment to the charge. If the federal government is seriously disposed towards ensuring speedy trial of this case, or if at all they have a case against our client, the business of court yesterday was to hear this application, challenge the region of the court. And if the court hears it and said, look, this application is not meritorious, we can proceed with trial, then we move on. And if the court hears it and said, look, there is no charge before me, there is no offense disclosed by the charge you file against this man, and as such, I will not call him to go into trial because of trial. He has to go. Then that will be the end of the case. But Because they don't want the matter to go on, they amended their charge, filed and served us 24 hours before the date set for the hearing of the case. So in that case, it wasn't amended in good faith. And the essence or intendment is nothing but to truncate the proceedings of yesterday, which they succeeded in doing, because we are ambushed. So it's an application apparently filed in abuse of court process. You're not given time to look at the charge. You're not given time to interact with our client before the date. The matter was adjourned for hearing. That was yesterday. So we said, okay, no problem. We came to court yesterday. The court was told that our client cannot take plea to the charge because this is not a Biafran republic. This is a country founded on rule of law, and this is a democratic institution. Justice must be done to all parties, all manner of parties. Not only be done, it must be manifestly be seen to be done to parties. We objected, and our objection was upheld by the court. And consequently, I joined the matter for him to take plea, allowing us time to have interaction with him on the extent of the charge before him. We have looked at the amended 15-count charge. That charge, the recent one they filed, is as useless, worthless as a paper you can probably as a drafting sheet paper. It's even more frivolous, more offended, more ridiculous than even this amended 7-count charge they filed, because it's for the duplicity of counts and a number of deficiencies and issues. So the entire 15-count amended charge disclosed no offense against Nnamdi. That I can assure you for sure, 100%. And we have done the needful. We are awake throughout the night. Of course, you had the SN leading us, who told you when we went to bed this morning at 4 a.m. this morning. We worked on throughout the night, and they wrote about for 2-page documents. That's the objection to the charge. And we were able to demystify the 15-count charge one by one. We took them one by one and sufficiently addressed it. So, and on the face of that application, the court cannot proceed. Because application is not only important, it's fundamental to the jurisdiction of the court. What we are saying is that in view of the fact that this amended 15-count charge preferred against our client disclosed no single offense was error that he has committed, that substantially bereft the court of the jurisdiction to proceed, because there's no charge before the court. So we are now inviting the court in the circumstance to examine what we filed before him, take decision one way or the other, and determine for the fall whether there's a charge before him. If the court found there is no charge, that the charge filed is as good as worthless paper, as good as drafting sheet, as good as tissue paper, the court will have the option that to do the needful by dismissing the charge in its entirety and acquit our client. So, of course, you see today the court made it abundantly clear that she will hear this application before proceeding. So that was actually what happened today. However, I wish to observe, because I want to tell you what transpired in open court, because we weren't there. There was a report of compliance, partial compliance out of court made by the civil services. The reported compliance on aspect of some directive given by the court on the welfare of our client. The reported compliance so much to have been further prompted. Apart from the fact that the issue of his dressing was also discussed, because court mandated them that they should change his clothes. It should be changed. Clothes should be changed before today's hearing. But their predicament was explained to the court and also to us before the court started. However, that should have been resolved by now, because we are making some clothes available to him. So, other issues and strategies we intend to adopt in the course of the hearing or trial, they will remain private. But I can assure you that there will be light at the end of the tunnel. That is settled. That I can assure you. So I believe today is a good day, and of course you can see our clients very delighted about the outcome of today's proceeding. We have no doubt whatsoever that our defense has been fortified, and there's no escape route.
All right, thank you very much, Barrister. One question and concern I have here is, I've been an old man in this case, ranging from when I would allow me to say during the first missionary journey of Nnamdi Kanu. I mean, the first time he was arrested and brought to court, there were various occasions, the FG, the prosecution did amend charges, charges upon charges in the middle of trials. They would from nowhere bring and attack charges, trump up charges, just to truncate the proceedings. And this time around, the second missionary journey, so to say, do we have any hope saying that such thing would not happen or repeat itself?
Thank you so much. We have to be mindful of the fact that that entire schedule of the court and also the entire movement of the case.
Exactly my point.
And we the defense team will not put our hands, because they want to railroad us into taking taking a dimension that will please, that probably that will give them what they want. So we have to advise ourselves when such thing happen. We have to smart enough to understand the strategy they are adopting, which is dangerous to our case, and also to adjust to a strategy or a strategy that will assist our case. So that was why we said no, we can't proceed. Because if they had wanted them to go on, it would have gone on yesterday. If the court has had our application yesterday, probably the court would want the application for ruling. Then or proceed for trial if the court so pleases. But they have a reason for filing this amendment at 11th hour. At 11th hour. You won't tell me that the prosecutor were not there since December last year. They were there. I don't think they traveled for Christmas because they were here working. If they had wanted to amend the process in good faith, they would have done that.
Thank you for watching. If the video interests you, please share.